Hello everybody, welcome back to the Praetorian. Before I get started, I'd like to start off with my usual introductory statement. Thank everybody for listening, and we appreciate all the likes, the subscribes, and we would also appreciate it if you could share these posts. The reason why it's so important to share these posts is because the Praetorian is 100% organic reach. That means that we do not pay for boosts, we do not pay for subscribers or likes. This is 100% organic, and we take pride in that. We wish to bring information to people with as little money involved, make it as free and cheap as possible for everybody. We don't support Patreon and people having to pay for any kind of information in the media that most of the supposed alternative media sources claim that they believe in. So by doing this, we believe that it's actually working on the problem when it comes to internet alternative media, and it's not hiding our heads in the sand. So that's why we do this. So if you could please like, subscribe, and share, we would greatly appreciate it. With all that said, let's continue with the topic. Thank you. Today, I'll be discussing the law, specifically the law of the United States. The federal court system and the judicial authority to interpret the Constitution received little attention in debates over the drafting and ratification of the Constitution. The power of judicial review, in fact, is nowhere mentioned in it. Over the ensuing years, the question of whether the power of judicial review was even intended by the drafters of the Constitution was quickly frustrated by the lack of evidence bearing on the question either way. Clerks hired by each of the justices of the Supreme Court are often given considerable leeway in the opinion they draft. Supreme Court clerkship appeared to be a nonpartisan institution from the 1940s into the 1980s, according to a study published in 2009 by the Law Review of Vanderbilt University Law School. As law has moved closer to mere politics, political affiliations have naturally and predictably became proxies for the different political agendas that have been pressed in and through the courts. While framers such as James Madison and Alexander Hamilton argued in the Federalist Papers that their then proposed Constitution would not infringe on the power of the state governments, others argued that expansive federal power is good and consistent with the framers' wishes. The 10th Amendment to the United States Constitution explicitly grants powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. The Supreme Court has been criticized for giving the federal government too much power to interfere with state authority. One criticism is that it has allowed the federal government to misuse the Commerce Clause to upholding regulations and legislations which have little to do with interstate commerce, but that were enacted under the guise of regulating interstate commerce, and by avoiding state legislation for allegedly interfering with interstate commerce. Article 3, Section 2, Clause 1. Citizens of different states are citizens of the United States. Cases arising under the law of the United States and its treaties come under the jurisdiction of federal courts. Cases under international maritime law and conflicting land grants of different states come under federal courts. Cases between U.S. citizens in different states and cases between U.S. citizens and foreign states and their citizens come under federal jurisdiction. The trials will be in the states where the crime was committed. Article 3, Section 2, Clause 2. The Supreme Court has original jurisdiction in cases about ambassadors and other public ministers and consuls for all cases respecting foreign national states. Article 3, Section 2, Clause 2. This is the rule for federal court to take a case. Original jurisdiction. Article 3 describes the court system, the judiciary branch, including the Supreme Court. There shall be one court called the Supreme Court. The article describes the kind of cases the court takes as original jurisdiction. In 1891, Congress enacted a new system. District courts would have original jurisdiction. Article 3, Section 2, Clause 2. The Supreme Court has original jurisdiction in cases about ambassadors and other public ministers and consuls for all cases respecting foreign national states, plus original jurisdiction over a small range of cases. Judicial restraint. A case cannot be hypothetical or concerning a settled issue. In the U.S. system, someone must have direct, real, and substantial personal injury. The issue must be concrete and ripe, that is, of broad enough concern in the court's jurisdiction that a lower court, either federal or state, does not geographically cover all the existing cases before law. Justiciability. Concerning the limits upon legal issues over which a court can exercise its judicial authority. It includes, but is not limited to, the legal concept of standing, which is used to determine if the party bringing the suit is a party appropriate to establishing whether an actual adversarial issue exists. Essentially, justiciability in American law seeks to address whether a court possesses the ability to provide adequate resolution of the dispute. Where a court feels it cannot offer such a final determination, the matter is not justiciable. Justiciability is one of the several criteria that the United States Supreme Court used to make a judgment granting writ of certiorari, cert. In order for an issue to be justiciable by a United States federal court, all of the following conditions must be met. The party must not be seeking an advisory opinion. There must be an actual controversy between the parties, meaning that the parties cannot agree to a lawsuit where all parties seek the same particular judgment from the court, known as a collusive suit or friendly suit. Rather, the parties must each be seeking a different outcome. The question must be neither unripe nor moot. An unripe question, one for which there is not yet at least a threatening injury to the plaintiff, or where all available judicial alternatives have not been exhausted. A moot question is one for which the potential for an injury to occur has ceased to exist, or where the injury has been removed. However, if the issue is likely to recur, yet will continually become moot before any challenge can reach a court of competent jurisdiction, capable of repetition yet evading review. Court may allow a case that is moot to be litigated The suit must not be seeking judgment upon a political question. Political questions involve matters where there is a textual, demonstrable constitutional commitment of the issue to a coordinated political department, meaning that the U.S. Constitution requires another branch of government to resolve questions regarding the issue. A lack of judiciary discovery and manageable standards for resolving it. An impossibility of deciding a matter without an initial policy determination of a kind clearly for non-judicial discretion. An impossibility of a court undertaking independent resolutions without expressing a lack of the respect due coordinate branches of government. An unusual need for unquestioning adherence to a political decision already made. A potentiality of embarrassment from multifarious pronouncements by various departments on one question. Political questions include such issues as whether the nation is at war with another country or whether the U.S. Senate has properly tried to impeach federal officers. If the case fails to meet any one of these requirements, the court cannot hear it. State courts tend to require a similar set of circumstances, although some states permit their courts to give adversarial opinions on questions of law. Alright, we have come to the end of our 15 minutes, so I'm going to stop here and I will get back to this later on at a better time. I would like to say again, thank you for listening and have a good night or a good day.